So good evening, members. Today we will be analyzing the probate and administration revision chart flow. This is an overview of what this unit entails you to have mastered. The same document was originally done by Betty Muthoni and Wanja Mukiri, who are now advocates, and maybe perhaps circumstances will have changed. Maybe they are not advocates per se, but I, Victor Ngaruya, I decided to modify the same in 2026 and included the drafting elements part of this chart flow. This chart flow is very important when you will be doing your orals. It is expected that you cannot go into an oral examination setup if you have not tried to know what the revision chart flow entails you to have mastered. So I'll jump straight in. Luckily it is visible before your end. And I will start with testacy and various elements that form drafting of a good will or a valid will is where we have the identity of the people. You give the details of the testator, i.e. the ID number, the name and the address. You give that he has the capacity, he is an alert of sound mind, and that if at any time he revokes this will, it will revoke all previous will that have been written in pursuant to this will. And execute, you appoint an executor and put his details. You insert the ID name, number and address. And when you have wishes and expression, it should state will happen to the body after you die. E.g. where you want your body to be cremated, this is allowed to be captured under the will. And we also have bequest. These are gifts given to different beneficiaries. And we have preemptive clauses that state what will happen if a beneficiary dies before the testator. Then you have witnesses. Make sure that there are two or more beneficiaries or spouses of beneficiaries. Where you want to have beneficiaries being witnesses, make sure you have two independent witnesses. Okay, attestation, this is where you explain the circumstances under which the will was signed and witnessed. And then the signature, this is the signature of the testator and witnesses' signatures. And the law relevant to testacy are covered under section 5 all the way to section 5 all the way to section 13 of the Law Succession Act. So that was just an introduction to what forms part of a will, because you can be told to draft a will. So remember to capture the identity, capacity, revocation, who is the executor, wishes, bequest, preemptive clauses, witnesses, attestation, and signatures. Then another roadmap is where we have wills. These are documents which a person expresses his wishes or intentions pertaining to devolution of property upon his death. And it does not take effect until the person is deceased, and the validity will fall on the three pillars. We have capacity, knowledge and approval, and formality. Inside capacity, this is where the lecturer will be glad to test you landmark decisions pertaining capacity, and even examination situations, they will tell you a person did not have capacity in one way or another. So how will you test whether a person to section 5 of the Law of Succession Act had testamentary freedom and capacity? You check on the age. A person must be of majority age, which is 18 years and above, and a child can also make a will. However, it will not be enforceable until they reach the age of majority, and they will now have to ratify the same. When it comes to capacity part, the general rule is that all persons are of sound mind unless proved otherwise, and the burden of proof that the testator is not of sound mind will lie on the person who alleged the same. And there is a landmark decision known as Bank versus Goodfellow, and this Bank versus Goodfellow lays out the three things that you should check when it comes to soundness of mind when you want to prove capacity. That a person must be able to recall all beneficiaries. The person must be able to recall all their properties. And C, they must understand the importance of drafting their will. These three elements must occur concurrently, and if one of them is missing, soundness of mind will be missing. Are you in a position to recall your beneficiaries? Are you in a position to recall your property? And do you understand the importance or nature of what you are doing? There are some factors that affect the soundness of mind. We can have a disease affecting the testator's mind such that it touches any of the elements mentioned in section 5 will be a ground for lack of capacity. This will lead to the will being invalid. This was held in the case of Harwood versus Barker, where the testator left a will in favor of the second wife at the exclusion of everyone else, and the will was challenged, and the court held that the testator was not of sound mind due to the disease affecting his mind. He was unable to recall other beneficiaries, and hence the will was declared invalid. Another situation, we have Banks versus Goodfellow on insane delusions. When it comes to an insane delusion, this is also a factor affecting soundness of a mind. We have disease number 1, we have insane delusions. A person suffering from insane delusions can make a valid will when they are having a lucid moment. And in the case of Banks versus Goodfellow, a soldier came from war claiming that he was being haunted by his friend who had died at war. He made a will and the will was challenged. It was held that it was proved the will was made during the soldier's lucid moment and as such was valid. Banks versus Goodfellow decision. Section 6 provides an appointment of an executor and must be done through a valid will. And section 7 provides for knowledge and approval. Anything that denies the testator of knowledge and approval will invalidate the will. It must be acknowledged at the date of execution of the will. It is at the time of executing the will, and the burden of proof is on the person alleging the same. And these factors that affect knowledge and approval will include the following. We have fraud, misrepresentation of something that is made to be true when it is not, denies that the testator of knowledge and approval because their judgment is based on a false fact. We have a decision, estate of Posner. A testator left a will in favor of a woman who had misrepresented herself as his wife. The woman was married to another man at the time and the will was challenged. It was held that the woman misrepresented herself as having the capacity to marry the testator, which she did not have, and therefore the will was declared invalid. So these are the factors that affect knowledge and approval of challenging a will. Then you have the case of Maingi versus Maingi, where the testator married the first wife under customary law and the second under statutory law. He made a will appointing his second wife as the executor, and the first wife challenged the will. It was held that the testator had misrepresented as himself as having capacity to enter into a statutory marriage, which he did not. The will was therefore declared invalid. The other factor that affects knowledge and approval is coercion and persuasion. Coercion means that anything that places pressure or additional requirements denies them of the element of free will and hence removes knowledge and approval. It is illegal. Persuasion, on the other hand, anything that appeals to the emotional connections made does not deny the testator free will and is allowed. This is how the CLE will put it before you. They will test whether you read the case of Hall versus Hall, where the court stated that anything that applies pressure on the testator to make the will in a certain way denies them of knowledge and approval and will be considered illegal. Persuasion, on the other hand, is allowed, though as it appeals to the emotional connections made and does not deny the testator of knowledge and approval. It is therefore legal. Persuasion is legal, coercion is illegal. If you read the case of Wingrove versus Wingrove, a man was caught in the pursuit of a harlot and was persuaded by the woman to make a will in her favor, which was then challenged, and the court held that the harlot had appealed to the emotional connections made and did not coerce the testator, hence the will was valid. The other factor affecting knowledge and approval, we have undue influence. This normally applies in personal relationships where we have trust and confidence. and one of the parties decides to take advantage of the relationship, influencing them to make a will in their favor, this will deny a testator of knowledge and approval, therefore invalidating the will. This was tested in the case of Revocation, where the testatrix had a spiritual advisor who claimed that he could get messages from the other side on how the testatrix was meant to dispose of her property. And when she died, she left the will in favor of the spiritual advisor, and this will was challenged. It was held that the will was invalid on the grounds of undue influence. Then you have the case of Pettis versus Lawless. Testatrix left residual estates to Roman Catholic priest who lives with and her husband. Court found no evidence of undue influence. We have another factor known as suspicious circumstances. So remember, when it comes to the factors affecting knowledge and approval, we have fraud, we have coercion, we have undue influence, and we have suspicious circumstances. Where the maker or the drafter is an advocate of the will, benefits substantially from the will, this is normally considered suspicious, and it is up to the advocate to prove otherwise. This was in the case of Whitley versus Nee, where the testatrix was an elderly woman with no financial expertise. She put her trust in the solicitor, who was the primary beneficiary. It was said that this raises suspicious circumstances, and therefore it was invalid. We have another case of Barry versus Butlin, where the testator went to the advocate's house and requested the advocate to draft a will in their own handwriting. In the will, half of the property was bequeathed to the advocate and the other half to his family. This will was challenged on grounds of suspicious circumstances, and therefore the will met all the requirements, and there was two independent presence. The will was declared valid. Because the will was declared valid because it met all other requirements, where we have two independent witnesses present, and the will was therefore valid. The other factor, we have mistake, true intentions not represented in the will. This was tested in the case of Morris, where the testatrix had requested the advocate to amend a section of her will such that it will only affect specific beneficiaries, but the advocate made a mistake in that all beneficiaries were affected. It was held by the court that the amendment did not represent the true intentions of the testatrix, and hence the will was declared invalid. Then you have inopportunity, insistent begging by a person to the testator to leave them something in the will. This is insistent nature will deny the testator of knowledge and approval. So basically, the examiners will want to confuse you with various elements that will make sure you don't understand what factors are there to affect knowledge and approval. We have categorically said that knowledge and approval is one of the three pillars. We have capacity, knowledge and approval, and formalities, where a student should always confirm whether that will meets the criteria. Knowledge and approval has various factors that can affect that principle. We have the fraud element, we have coercion, we have undue influence, we have suspicious circumstances, and we have inopportunity and mistake. Inopportunity is the insistent begging by a person to the testator to leave them something in the will. Then if we are to scrutinize formalities, this is pursuant to section 8 of the NSA Act. A will may either be oral or written. And when it comes to oral wills, they are divided into two. We have oral wills and privileged wills. When it comes to the oral wills, the requirements include the person making the will must die within 3 months, and there must be at least 2 witnesses. On the other hand, privileged wills, these are reserved for person or people in active service, e.g. military and maritime personnel, because of the constant danger they face performing their duties. And the requirements are: it has no time limit instead of expiring when active service ends or the ship reaches the port. The person must be in active service or at sea, and 1 witness must be present. I will read out directly the interpretation of section 9 of the Act to avoid a situation where we are overthinking, and read it verbatim. I'll project before you. This is it. Section 9. No oral will shall be valid unless it is made before 2 or more competent witnesses, and that the testator dies within a period of 3 months from the date of making the will. Provided that an oral will made by a member of the armed forces or merchant marine during a period of active service shall be valid if the testator dies during the same period of active service, notwithstanding the fact that he died more than 3 months after the date of making the will. Okay, so there is no time limit when it comes to privilege wills. No oral will shall be valid if, insofar as it is contrary to any written will which the testator has made, whether before or after the date of the oral will, and which has not been revoked as provided under Section 18 and 19 of the Law of Succession Act. So I tend to disagree with this document. Where did they get the element of one witness? But we agree to the extent that it has no time limit. There is a decision known as the estate of Ada Stanley, where the testarist had received a letter that her services will be required at war. She wrote a letter to her friend and states that if she died at war, all her property should go to the friend. When she died, her family were claiming that she died intestate. It was held that the letter amounted to a privilege will, and it was admitted to probate. We have Gathward versus me. A soldier received instructions that he would be going to war. When he was at war, he wrote a letter to his friend and stated that if he died at war, all his property will go to his friend. He died at war, and the father claimed that he died intestate. The letter amounted to a privilege will and was admitted to probate. Then we have the concept of written wills. Section 11, it says that written will must be in writing and properly executed. If the testator can't write, they can't sign with a thumbprint, or someone else can sign on their behalf in their own signature in front of the executor and with their direction. Both witnesses must see the will being signed by the testator or the person signing on their behalf. This is what we call acknowledgement. Both witnesses don't have to sign the will at the same time. They can sign the will on separate occasions, but before the presence of the testator. Witnesses have to be literate, but the testator doesn't have to be. Section 12 tells us on incorporation of papers not attached to the will by reference in the will or codicil. We have Section 13 tells us on beneficiaries attesting to a will. We are told that a beneficiary can attest to a will, but for the will, however, there must be 2 other independent witnesses apart from the beneficiary. If not, their bequest will be invalid. However, the validity of the will is not affected. It only affects what they are to be bequeathed. This was seen in the case of Bravanda, the estate of Bravanda. The will was invalidated as the only 2 witnesses were the daughters of the testator, and they were also the only named beneficiary. Section 14. Witness not disqualified by being executor. Section 16. A will is valid if executed according to the law in force at that time. Section 17 tells us about revocation, alteration, and revival of wills. A will may be revoked or altered. A person may revoke or alter their will any time in their lifetime. They can also revive any of their wills at any point in their lifetime. Alterations without changing the whole will are done through a codicil. And a codicil is a document that explains or gives further directions or bequests certain things in a will. It does not exist on its own, as it is a supplementary document to the will. It must be dated and witnessed. If the will is not found, there will be a rebuttal presumption that it is lost. We have voluntary revocation. Under voluntary revocation, pursuant to Section 18(1), we have express revocation. Now we have a new will or a codicil. it should state that it revokes all other previous wills to safeguard against any future issues. It may also be done by burning, tearing, or otherwise destroying. And two things must be present concurrently and be fulfilled for any voluntary revocation through the destruction of a will. We must see intention to destroy the same, and we must see the actual destruction. Intention plus actual destruction. Is it by tearing up the will completely? Is it by burning the will and scratching out vital parts of the will? There are some landmark decisions that you can be asked during orals on Chis versus Lovejoy, where the testator made a will and wrote at the back at some point later, "This has been revoked," and threw it in the dustbin. The cleaning lady picked it up from the dustbin and put it in the kitchen drawer. 8 years later, the testator dies and the will was brought to court to give directions on its validity. It was held that although the testator had the intention of destroying the will, he did not succeed in the actual destruction. Hence, the will was held to be valid. In the case of Ree Jones, an old lady in a hospital made a will in favor of her nieces who used to visit her. After informing them of the will, they stopped visiting. On her deathbed, she scratched out the signatory part of the will. The will was brought to court to give directions on its validity, and it was alleged that the old lady had the intention there was actual destruction. That is the case of Ree Jones, as compared or contrasted with the case of Chis versus Lovejoy. Okay. Section 18.2 talks about an implied revocation element. If the testator had another will that was executed after the will the beneficiary wishes to rely on, the older will is revoked. A written will may not be revoked by an oral will. Then you have section 19 on involuntary revocation. This is where revocation occurs through operation of the law when the testator gets married. However, if the will mentions that will happen should the testator marry, a term contemplating marriage and its effect on distribution of the property, then the will may still be valid. In Kenya, there are no cases for construction of a will, as the beneficiary and dependents only wish to find out what they stand to gain. That is subject to further research to confirm the same. So the key takeaway is that we have involuntary revocation by operation of the law. If the will contemplated that I'm going to enter into a marriage, a term contemplating the marriage and its effect on distribution of the property, then the will may still be valid, if I capture that clearly. Section 20. Effect of obliteration or alteration in a will. Alterations should be signed in the same manner as the will. This is why it is signed and witnessed. Section 21. Revival of wills. A will is re-executed in the same manner as the first will, and date of execution is equal to date of execution. This is what we call revival of wills. You can revive a will through re-execution of the same. The date of execution is to be maintained as to be the date of execution of the re-executed document. Then you have section 22 and as read together with schedule 1 of the Act, where we have construction and interpretation of wills. If a will is uncertain and ambiguous, a judge may either declare the will invalid or benevolent approach. This is why you interpret the will to bring to life the wishes of the testator. Because the rules, Probate and Administration Rule 78 in Schedule 1 helps the court to interpret a will. And the duty of the court is to construe the will not to remake it, to interpret the will as it is and have a mechanical interpretation. And primary meaning of the word, when read in its ordinary natural sense, the court is to use the primary meaning of the word, unless a different definition is given in the will through a dictionary or children includes grandchildren. If the word has more than one meaning, the court has discretion to apply the meaning that appears most probable. The other rule is that derive intention or meaning from the entire whole will. Then the will speaks to the property the testator owns at the time of they died, not when it is being written. So the property is at the time of the deceased man, not at the time he was writing a will. And when ascertaining beneficiaries, it is generally construed to refer to people at the date the will was being made. Construction and interpretation of wills. Then we have section 23 and the second schedule, failure of testamentary disposition. It tells us that the disposition shall fail by way of lapse of ademption if the following happens. Where the beneficiary predeceases the testator, an intention for joint tenancy will not fail. However, if the intention is to create tenants in common, the disposition will fail. The beneficiary predeceases the testator, that will fail under the lapse of ademption. All members of the class predecease the testator. A class gift is one where the beneficiaries fit a certain description, and the amount that each beneficiary receives depends on the number of the people in the class. The effect of a lapse in that property will revert back to the estate of the deceased and be distributed intestate. But we have various exceptions. Where the gift was discharged in recognition of a moral obligation, where the beneficiary dies immediately or soon after the deceased, and where the gift was to a child or children of the deceased or any other descendants of the testator. Then, another potential question that you can be asked is on election, pursuant to section 24 as read together with the third schedule. If a testator bequeath property that they didn't own to the person who holds title over the property, the beneficiary may elect to give effect to the testator's attempted disposition or enforce their property rights, proprietary rights. The beneficiary cannot be seen to enjoy both rights and must choose one, election or enforcement. I repeat, if a testator has bequeathed property that they did not own to the person who holds title over the same property, the beneficiary may elect to give effect to the testator's attempted disposition or enforce their proprietary rights. The beneficiary cannot be seen to enjoy both rights and must choose one, election or enforcement. It is immaterial whether the testator was aware that they lacked title. Election may be express or implied, and someone who has been seen to have accepted the beneficial provisions of a will is barred from rejecting the disadvantageous terms. It will be against the intentions of the will. You must understand what we mean by election, ademption, and lack of time. Let us check the differences between the two. Ademption, election, and lapse of time in a will. Basically, ademption occurs when a specific gift is destroyed or sold before the testator's death. Lapse occurs when a beneficiary predeceases the testator, and an election requires a beneficiary to choose between a bequest and their own property. Ademption in details. Under Section 23 of the Law of Succession Act, a specific gift will fail or redeems if the property no longer belongs to the testator at the time of their death, or if it has been fundamentally converted into property of a different kind. The key rule is that the beneficiary receives neither the property nor its sale proceeds. But there is an exception. If the change in the property's form is merely nominal, e.g., the shares transferred to a reorganized corporate entity, or the gift remains valid. So if there is a change in the property's form in a mere nominal manner, that is where we'll have an exception. But generally, a beneficiary will receive neither the property nor its sale proceeds. Then what is lapse? According to Section 23 of the Act, if an intended beneficiary predeceases the testator, the specific bequest to them will lapse. And the key rule is that lapsed gifts do not automatically go to the deceased beneficiary's heirs. Instead, they fall into the residuary estate and are distributed to the residuary beneficiary. There is an exception. If the lapsed gift is the residuary estate, it will pass to the deceased testator's heirs through the rules of intestacy. Election. Provided under Section 24 of the Law of Succession Act. The doctrine of election applies when a will purports to give a beneficiary something that actually belongs to them, while simultaneously granting them another benefit. The key rule is that the beneficiary is forced to elect or choose one. They must either accept the gift under the will and surrender their own property to the estate, or reject the will's gift entirely and keep their own property. You have to elect, you have to choose one. Lapse of time. The lapse of time generally refers to delays in the legal administration of the estate following the testator's death, and the key rule is that while the lapse of time does not void the will, beneficiaries cannot claim ownership of their inheritors until the High Court or a magistrate court confirms the grant of probate or letters of administration. There is a legal limitation under Section 30 of the Act that any dependent wishing to challenge the will for inadequate provision must bring the application to the court within 6 months of the date of the grant of representation. So to that point, we have understood what we mean by election, ademption, and lack of time and the exceptions thereto. Then let us read about dependents. About dependents. Section 26 of the LSA Act provides for provisions for dependents not adequately provided for by will or intestacy. Testamentary freedom is curtailed and states that the testator should make adequate and sufficient provisions for all dependents who are in their care before their death. And the section allows for the dependent who is not adequately and sufficiently provided to ask the court. Now the case of Ndolo versus Ndolo. He had married 3 wives and he had died tested. He bequeathed everything he had to the last wife. The other 2 wives challenged the will. The court found the will invalid, stating that the testator cannot leave out their dependents even if they choose to give all their money to charity. Then we saw the case of Reuben Zioka Mutua, where he had married his first wife under the statutory regime in Nyeri and had 7 children with her. They were separated by the time he passed away. And after he died, a woman stated that she and the deceased had married under Kamba customary law. He had made a will and hadn't included the other woman or their 3 children as beneficiaries. And the court had to determine if the second wife was a wife under the law and if the children should inherit. It was held that the children should inherit under Section 26 as they are Mutua's children, and the second wife was not a wife under the law at that time, as Mutua had married under the statute. Any other marriage after that was not valid. This was also captured under the decision of Irene Njeri Macharia versus Margaret Wairimu Njomo, where the court recognized the child of the deceased born to another woman rather than the wife. They awarded to the child through the mother all the property of the deceased except a house he owned jointly with his wife and 10 shillings. It was felt the child needed the money more than the widow. Discretion of the court in making an order. Pursuant to Section 27, the court has complete discretion on making provisions for a dependent. It can either award in lump sum, amount, or periodical payments. What are the circumstances to be taken into account by court in making the order? They will look at the nature and amount of the deceased property. They will look at the past, present, or future capital or income of the party dependent. They will look at the existing and future means and needs of the dependent, whether the deceased had made a gift to the dependent prior to the death, what is the conduct of the dependent in relation to the deceased, what are the circumstances of the other dependents and beneficiaries, what are the testator's reasons for not making the provision. So those are the circumstances to be taken into account by court in making a reasonable provision order. Nature, past, existing, future means whether the deceased made a gift to the dependent prior to their death. Is there the gift? What is the conduct of the dependent? Circumstances of the dependent's testator's reason. Section 29 tells us our own meaning of dependence. And Article 53 of the Constitution, together with Section 32, speaks of children. All children have a right to inherit from their parents' property. Any child who was not the deceased biological child but was being maintained by them and was treated as their actual child will qualify as a dependent. We have wives. So this is the part where we will analyze person to the various decisions. And it is this part where I'll give the interpretation of Section 3.5. I'll give the jurisprudence behind Section 3.5 of the Law of Succession Act. Then we'll end the day and pass on to that part. Then when we resume, we'll discuss on dispositions which pass without a will. Then we'll go to intestacy. Then we will analyze various duties of the administrators, various grants to be issued and obtained, various terminologies used in this unit, and we will do the actual draftings of the documents required in this unit. So I want to clarify the jurisprudence behind Section 3.5, and I will ask this question in our oral discussion because at the time of making this projection, it was on 11th July 2026. There is a decision that has been made by the High Court just some 2 days ago. So at the time of doing this publication, it was in 2023. We will go through the same because it is important we understand where the jurisdiction, where the jurisprudence came from. Before the Law of Succession Act came into force on 1st July 1981, two vital case laws will be subject to judicial lenses, posing a glaring imbroglio that will later be saved from the historical enforcement of the Act of Parliament. All this started from a judgment delivered in Jembe versus Mwondo, where Bad Justice, as he was then, said that the fact that the deceased married a wife according to the rules of the Anglican Church does not affect the succession to his property, and such succession must be regulated by native law or custom. This view will later be upheld in judicial decisions like the Ruwenji's estate and the Ri-Ogola's estate, because although the Law of Succession Act had been passed, it was yet to be operationalized. Let us look at the various contentious case laws. In the case of Re-Estate of Boaz Harrison Ogola, 1978, a claim to a share in the estate was made by Bona Awino Ogola on the grounds of being a customary marriage to the deceased on 1st March 1974. And Miss Awino also claimed on behalf of her daughter, whose father, she said, was the deceased. However, the assumption that Bona was married to the deceased in accordance with Luo customary law, a preliminary point was argued, namely, whether or not a wife married under customary law could inherit any part of her deceased husband's intestate estate when a wife married to the deceased under the African Christian Marriage and Divorce Act prior to the customary law marriage was still alive. The same question was also considered in the Ruwenji's decision 1977, where two ladies claimed to have been married to the deceased under Kikuyu customary law subsequent to his marriage to another lady under the African Christian Marriage and Divorce Act. And such Deva Jai had held that any such marriage was null and void and that the ladies were not entitled to any inheritance from the estate of the deceased. With respect to that holding, Simpson Justice entirely agreed with the decision of such Devaje, where in verbatim he decided to state that to decide otherwise will be to condone the offense of bigamy. An African in Kenya is not obliged to marry under the Marriage Act or the African Christian Marriage Act and Divorce Act, but if he chooses to do so, he is choosing the Christian way of life, which recognizes only one wife and on his death removes the widow and children from the ambit of tribal customs affecting cohabitation and guardianship. Thus, I hold that the Bona was not lawfully married to the deceased, and neither she nor her daughter is entitled to a share in the estate. Those two matrimonial causes compel the court to look into the rights of married women who were caught up in a polygamous labyrinth. And both causes were hinged on Section 37 of the Marriage Act that was repealed, which stated that any person who is married under this act shall be incapable of contracting a valid marriage under any native law or custom. This provision was therefore overriding any customary law application, and in effect it meant that if a man who was married under the act purported to marry another wife under customary law, it was not a valid marriage under the customary law, or otherwise, if it is not a valid marriage, the woman does not become his wife and cannot therefore inherit in that capacity. Further, the two judges, who are not of the African descent, were of the opinion that condoning such marriages will be tantamount to condoning the offense of bigamy. Notably, this was good law since at the time when the decisions were being passed in 1997 and 1978, that was the correct position of the law as it then stood. Then you have the introduction of Section 35 of the Law of Succession Act. After the Law of Succession Act came into force in 1981, Parliament intervened and added paragraph 5 to Section 3 of the Act via an enactment number 10 of 1981. And the intention of the legislature was to protect the women married polygamously to men who had also contracted statutory monogamous marriages. And now Section 35 provides that, notwithstanding the provisions of any other written law, a woman married under a system of law which permits polygamy is where her husband has contracted a previous or subsequent monogamous marriage to another woman, nevertheless, a wife for the purposes of this Act, and in particular Section 19 and Section 40 thereof, and her children are according children within the meaning of this Act. Surprisingly, even after the inclusion of this section, courts were still reluctant to give effect to Section 35, as it was seen in the case of Estate of Reuben Mutua and Nzioka, 1986, where the brief facts of the case were that the deceased married Teresia Mutua at a PCA church in Nyeri under the African Christian Marriage and Divorce Act, and in March 1980, Mutua once again, being true to the African manhood, purportedly married Josephine Mutua, and that marriage was said to have been conducted in accordance with Kamba law and custom. There were 3 children out of their union. That marriage was never dissolved until 26th May 1986, when Mutua died in a road accident. There were 7 children of the marriage. He died tested, but in his will he did not provide for Josephine and her children. She therefore produced her children's birth certificate as evidence that the deceased had recognized them as his own in accordance with Section 3(2) of the Act. On her own behalf, and on behalf of her children, she applied to the court under Section 26 of the Act for reasonable provisions to be made for her and her children out of Mutua's estate, and 3 issues arose for determination. Whether the deceased second wife, married under Kamba customary law, was a wife for purposes of the Act, and if not, whether a marriage could be presumed due to prolonged cohabitation, and 2, whether the children were lawful dependents of the deceased under Section 3(2) of the Act, and 3, what is the reasonable provision under Section 26 of the Act to make for both the second wife and her children. A careful and detailed judgment was made by the High Court, from which no appeal was apparently preferred. On the first question, the court decided that the deceased, having contracted a statutory marriage, he lacked capacity to contract another marriage under customary law, and therefore Josephine was not a wife for purposes of the Law of Succession Act and was not entitled to receive any provision from Mutua's estate. On the second question, the court held that Josephine's children were children under Section 3(2) of the Act, and therefore they were entitled to reasonable provision for their maintenance out of Mutua's estate. However, on that question, no provision was made because the judge noted that doing so will prejudice the work of the executor. Then came a departure from the Reuben Mutua's Nzioka's case by the Court of Appeal. With regard to the first question, the court was wrong because it did not address itself to the mischief in the law which Section 35 was meant to address, and the fact that the definition of wife under Section 35 is wide enough to include persons of Josephine's position. Suffice to say that Kamba customary law recognizes polygamy. Consequently, the decision in this case has been overruled in the Court of Appeal decision in Irene Macharia versus Margaret Nyomo and Patrick Harrison, 1994, where John and Njogu underwent a statutory marriage ceremony in 1978. The couple, however, separated in 1989, and Njogu took and started to cohabit with the first respondent. The two had a daughter known Jackie Njogu, and Mr. Njogu died in 1990, and the dispute that arose was how the property left behind by the deceased was to be shared out between the appellant and the infant Jackie. In the first instance, the court held that under Section 35, a woman married to a man who had contracted a statutory monogamous marriage was a lawful wife for the purposes of the Act, and her children are accordingly children within the meaning of the Act. And the court also held that Ruenji's estate and Riogola's estate are no longer good law as they were decided before Section 35 of LSA Act, before the same came into play, Section 35. And the court also held that the High Court decision in Mutua was wrongly decided. In a unanimous judgment, the Court of Appeal stated that the view that was held by both counsels and apparently by the Superior Court that the first respondent was not a wife for the purposes of succession was wrong. The court further stated that the decisions in the above two mentioned cases were at the time they were being passed correctly reflecting the position of the law as it was then. The courts then correctly held that Ruenji and Ogola were incapable of contracting other marriages. The court agreed with the appellant that as the widow, she was entitled to a share of her husband's estate available for distribution only because we want to attain that objective, namely not to disinherit a widow. Then came the Constitution 2010 and the Marriage Act 2014. Article 45 of the Constitution recognizes a family as the natural and fundamental unit in a society. Moreover, pursuant to Article 45(4) of the Marriage Act 2014 was enacted from the powers conferred upon by the legislature. The Act sought to recognize marriages concluded under any traditional or systems of belief, personal or family law, and family law under any tradition as required by the same enabling provision. To this end, the Marriage Act has emphasized on registration of marriage, including customary marriage, which is potentially polygamous pursuant to Section 6(1) of the Act. In addition, Section 3(1) of the Marriage Act defines marriage as a voluntary union of a man and woman, whether in a monogamous or polygamous union. What is the cohabitation in Kenya in light of succession courts? That was an obiter to the discussion before this court. The conclusion from this blog is that from the above analysis, it is evident that Section 37 of the Marriage Act has no consequence when it comes to inheritance. The section has been circumvented by Section 35 of the Law of Succession Act, which allows the woman married under a system of law which allows polygamy to a man who is already married under statute to be treated as a wife for succession purposes. The relationship between Section 37 of the Marriage Act and Section 35 of the LSA has therefore been stated with finality in the decision of Irene Macharia. Then, this brings us to 2026. There is a decision made by the High Court just previously. There is an amendment of the Land and Law of Succession Act amendment that was made, a bill that was passed in 2021, that deleted the definition of a former wife and replaced thereto with the definition of a spouse. But there is a silent amendment to Section 26, 29 of the Act. There are some schools of thought saying that that is an implied amendment to Section 29. But now that brings another question. If the legislature indeed wanted to amend Section 29, why did they drop it from the initial bill that was tabled before Parliament? And the bill only amended Section 35 of the Law of Succession Act. What is the position of former wives currently in Kenya? So that marks the end of this presentation on probate revision chart flow, and specifically under the jurisprudence surrounding Section 3.5 of the Law of Succession Act. That is an important analysis, and we will clarify the same from panel members when that oral question will be posed before them. So we will conduct part 2 of this flowchart so that we make sure we have captured everything to the latter. Thank you so much.